Good day. We'd like to first thank everyone for taking the time to join us for this virtual presentation on the Draft Environmental Reserve Bylaw 20036. For this presentation, you have myself, Carmela Green, Development Compliance Officer of Lakefront County, and Diane Cloutier, Manager of the Planning and Development Department. We have a presentation prepared today that we hope will provide some clarity on the Draft Environmental Reserve Bylaw, as well as promote education on how we can address encroachment issues on municipal land. After the presentation, there will be a Q&A session where we will answer some of the pre-registered questions that we have received to date. Please note that you'll still have the opportunities to submit any questions that may arise from the presentation to the draft bylaw at laklawishcounty.com email, which will be available along with the recording of today's presentation until March 31st. For those questions that we do not get the opportunity to answer within our allotted time, we'll be following up with all those residents to ensure you receive an answer to your inquiry.
So what is the purpose of environmental reserve lands? Environmental reserve lands' main purpose is to preserve the natural features and prevent pollution of land. These lands also provide for a means of public access to and from a water body. Lands can also be dedicated as environmental reserve to prevent future development on lands that are subject to flooding or are unstable. An environmental reserve is a parcel of land that the county has identified to be environmentally significant through its land use planning process. The province provides guidance as to what lands qualify for this designation. These lands are typically identified through the subdivision process and as a result protected from development. Bylaw 2036 defines environmental reserve as a parcel of land or part of a parcel of land designated as environmental reserve as defined under section 664, subsection 1 of the Municipal Government Act, or is identified through an environmental reserve easement. Any county-owned land which has another designation described on the certificate of title, for example, R reserve, which appears to bear the traits of an environmental reserve defined in the Municipal Government Act, shall be considered as environmental reserve and be subject to the provisions of the county's bylaws and policies.
Did you know that not every subdivided parcel that abuts a water body has designated environmental reserve? A few historical private parcels within our county own to the bank. As such, the bylaw would not apply for those historical lots or to lands that have not gone through the subdivision process. The Planning and Development Department can assist you in identifying if there is environmental reserve abutting your property. As well, residents can utilize the online mapping system MuniSite that is now available on the Lakefront County website, or review the description provided on the property title itself. This bylaw would apply to the 102 environmental reserve parcels currently within Lakefront County, and for any future environmental reserve parcels that are created during the subdivision process. There are approximately 664 private titled parcels that abut county environmental reserves. These property owners will be the most directly affected by the draft bylaw, and these abutting property owners will have new allowances afforded to them that we will discuss throughout the presentation. Currently, of those 664 parcels, there are approximately 292 private titled parcels that are developed with any significant structure, such as a residence or accessory building, that abut environmental reserves. I would highly recommend that landowners utilize the MuniSite program to verify that they have not developed outside of their property boundaries.
So who owns an environmental reserve land? During the subdivision process, a certified individual will examine the lands and complete the county's riparian matrix setbacks model, which will determine what area of land are environmentally sensitive. Dedicating lands as an environmental reserve ensures that sensitive banks and lake shores remain protected and that public access to them is maintained. Once the plan of subdivision is registered, the county becomes the owner of the environmental reserve lands. Lakefront County believes it is appropriate to regulate and manage environmental reserve lands to promote the safe, enjoyable, and reasonable use of the municipal lands while still protecting the integrity of the natural environment. Providing regulations also allow for a transparent and fair way to manage county-owned lands. Administration ensured that the Bylaw 2036 complies with the provisions set out in the Municipal Government Act. The Municipal Government Act is a provincial document that provides guidance and the legislation framework on how municipalities operate.
Staying status quo. So what if we did not proceed with the draft environmental reserve bylaw? In that instance, then the land use bylaw and policy regulations that are currently in place will be administered. Lakefront County will identify unauthorized uses and encroachments through observations by staff in the performance of their duties or through a complaint process. All illegal encroachments on environmental reserve land shall be removed or remediated. Additionally, any seasonal encroachments such as piers and boat lifts must be removed from the ER and returned to private property by November 1st of each year for the duration of the winter months, as per the current policy. As such, if the draft bylaw does not proceed, all encroachments would have to be removed to comply with the current regulations. Furthermore, existing municipal bylaw and policy do not allow the ability to enter into agreements to address encroachments existing or proposed on environmental reserves.
So why the need for an environmental reserve bylaw? The new environmental reserve bylaw provides a clear direction for administration regarding the management of environmental reserve lands. It offers a process for the licensing through the form of approvals and agreements on a case-by-case basis. The bylaw provides for provisions on how the county will manage the removal of non-permitted encroachments and issue fines and fees for non-compliance. After considering feedback from previous public engagement sessions, administration included new and expanded permitted uses that may occur on environmental reserve lands. These were not previously allowed under the existing bylaws and policies. Once the bylaw is approved, residents abutting environmental reserve lands will have the ability to apply for permission and further enter into an agreement for certain uses on environmental reserve lands.
So, current regulations. The provincial regulations that speak to the use and management of environmental reserve lands are set forth in the Municipal Government Act. The MGA is the legislative framework under which all municipalities in the province of Alberta operate under. As such, the bylaws created must follow the direction provided by the MGA, and that direction is that environmental reserves must be left in a natural state or be used as a public park. At the municipal level, the current regulations are set forth in the Lakefront County's encroachment policy and the land use bylaw that states no encroachments on environmental reserve land shall be permitted. These regulations are straightforward, however, do not leave any option for access considerations that were brought forth from abutting property owners during our engagement sessions. Upon the passing of the draft bylaw, the current municipal regulations would be amended to align with the new bylaw, and the existing encroachment policy would be rescinded, and a new environmental reserve management policy and procedure will be established to support the administration of the new regulations. The bylaw and subsequent policy and procedure will provide clear direction for administration regarding the management of environmental reserve lands and will provide county residents with guidance on the allowable uses of those lands.
So some highlights on vegetation control and maintenance in Bylaw 2036. As per previous environmental reserve bylaws and policies, residents are still permitted to hand pull weeds that are identified in the Weed Control Act within the reserve. The new bylaw 2036 also states that abutting landowners will now be allowed to clear and maintain a 10-foot wide single meandering trail where previous policies only allowed a 6.6-foot wide trail. The increase in size was in response to requests made by abutting landowners because the existing width made it difficult to properly access the lake shores to place and or remove boat lifts and piers. The trail is to lead from a private lot in a perpendicular manner, across the environmental reserve and be designated in such a way as to cause minimum environmental impact.
So, highlights on access. The county recognizes that not all environmental reserve lands are accessible. As such, a provision has been added to the bylaw to allow abutting landowners the ability to apply for an encroachment agreement to construct and access on sloped ER lands. This can include existing or new construction of stairways and or boardwalks to accommodate access through steep areas. Through our engagement process, we have heard from many residents that safe access is a concern. The new consideration is to address those areas that are not accessible due to topography and to provide residents with an option for access if they wish to create one. Regarding vehicle access, there unfortunately has been a significant erosion and drainage issues caused from unauthorized vehicle use on reserve lands throughout our municipality. These areas are intended for pedestrian access only. Therefore, vehicle access will be permissible only to abutting landowners who will be permitted to cross lands twice a year to accommodate the placement and removal of a dock, unless otherwise approved by the county. Say, should a resident require additional access use, they will have the ability to place a request to be considered and decided upon by the manager of planning and development. For residents that are not abutting the ER, such as backlot owners, they will have access to water bodies in the subdivisions through designated boat launch or public dock areas that are created and maintained by the municipality. This will alleviate further deterioration of environmentally sensitive lands.
Our highlights on major or existing major encroachments. Major encroachments are defined as an encroachment that covers 20 square meters or greater in area. Some examples would be stairs or pathways down to the waterfront or small structures such as a storage shed. Existing major encroachments cannot be grandfathered. For waterfront owners who have existing structures or pathways or stairs on the environmental reserve, they will have the option through Bylaw 2036 to apply for approval and an agreement, which would then permit the encroachment to remain on site. Where an encroachment exists without municipal approval, or if council denies a request to keep an encroachment on the environmental reserve, the owner will be responsible to remove it at their own expense. Unpermitted major encroachments will have to be removed and the lands reclaimed to a natural state within 90 days of the passing of the bylaw. If the encroachment is unclaimed, county staff will remove the structure. In the event that the county grants approval for an existing encroachment to remain on site and that encroachment is not listed as a permitted use within the new bylaw, so for example, a gazebo that was built prior to the passing of the bylaw, minor maintenance with no structural modifications will be allowed. If at any time the structure is in a state of disrepair or has been damaged or destroyed to the extent of 75% or more, the encroachment is not to be repaired or rebuilt except for in accordance with the municipal bylaws and policies.
Highlights on proposed encroachments. Upon the passing of the bylaw, abutting landowners will gain the ability to apply for a major encroachment agreement to accommodate the construction of stairs or boardwalk to create a safer access point through the environmental reserve parcel. To clarify, the agreements will be specifically for municipally owned lands and does not encompass any portion of provincially owned bank or bed and shore. Applicants requesting a new structure to be constructed intentionally encroaching onto an environmental reserve will need to submit a written request, providing the reason for the encroachment, including the legal description of the lands upon which the encroachment is proposed, and must be accompanied by a copy of title no older than 30 days and a real property report no older than a year, showing the site plan inclusive of measurements for the proposed encroachment. Upon receipt of a completed application, review will be undertaken by the Planning and Development Department and by any affected county departments. Applications for major encroachments that do not adversely affect county's lands and interest shall be considered and decided upon by County Council. Any applications received for the proposed encroachment of a residential dwelling, accessory buildings, or CCAN placement on environmental reserves will not be considered by council and will be refused, as those uses clearly do not follow the intent of the lands.
The highlights on new minor encroachment allowances. So a minor encroachment is defined as an encroachment that covers less than 20 square meters in area. Abutting landowners will have the ability to apply for an agreement to permit a minor encroachment on the environmental reserve. Some examples of minor encroachments are small storage containers or a short boardwalk or stairs leading to the waterfront. Boat lifts and docks are also considered as minor encroachments. Property owners abutting waterfronts who are unable to store their docks and boat lifts within their own property boundaries due to the topography of their lot may apply for an agreement to store these on the environmental reserve land. If an abutting landowner can easily locate the dock and boat lift within their own property boundaries, it will be expected that this be considered first. Minor encroachments that are non-permitted, minor encroachments that are non-permanent and no more than 0.66 feet in height and enclosing an area not exceeding 215 square feet, such as a stepping stone, are allowed with no prior authorization needed. Non-permanent storage containers that do not exceed 150 cubic feet in area also do not require an agreement or council's approval to be placed on the environmental reserve.
Highlights on fire pits located on ER lands. Our current land use bylaw prohibits all fires and fire pits on municipal lands. The draft ER bylaw continues the provision that all permanent fire pit structures are prohibited and will have to be removed by the owners. However, there is a new allowability for portable propane fire receptacles on ER designated lands. These may be placed temporarily and will need to adhere to the Lakefront County Fire Bylaw, which provides the distances required for placement as well as the size regulations of the receptacles itself, which shall be less than 2 feet high and less than 3 feet wide. There was a question raised on why portable wood burning fire pits are not a consideration. And this was due to the damage that can occur to the ground from the heat generated from the fire bowl, as well as the danger of flying embers and sparks from the wood fire itself. Taking all of those aspects into consideration, it was determined that wood burning fire pits would not be appropriate on environmental reserves. However, they are appropriate for private title properties where steps can be taken to protect the ground by installing barriers, as well placement in a cleared area to mitigate the danger of sparks of embers. Recognizing that forested wilderness is all around us, the county, through the Fire Services Department, organizes information sessions and open houses to teach community members about the importance of fire smart initiatives and fire prevention. All existing private permanent fire pits will have to be removed and the lands reclaimed to a natural state within 90 days of the passing of the bylaw. The county retains the right to remove and dispose of any unclaimed fire pits on environmental reserve, where in the opinion of the county, there is clearly defined need for a permanent public fire pit. The county may provide and maintain a public fire pit for general community use.
So what are our next steps? For residents who have submitted questions regarding the draft environmental reserve bylaw prior to today, Carmela and I will be answering them during the question and answer period. County residents will be able to submit additional questions that were not addressed or provide their comments on the draft bylaw through the draft bylaw at laklabishcounty.com email. This email will be available up until March 31st of this year. Administration will then prepare a report for council that will include all the questions and comments received since December 2020, along with a recommendation that council grant first reading to Bylaw 2036. Our goal is to have this prepared for the April 13th regular council meeting. Once the bylaw receives first reading, a public hearing will be scheduled. This will be a final opportunity for residents to speak in favor or opposed to Bylaw 2036. Information on how to pre-register to speak at the council meeting will be available on the county's website. Following the public hearing, council would then decide if they wish to endorse the bylaw and grant the final readings, or they may also choose to defeat third reading. If the bylaw does not receive all 3 readings, the regulations of the current land use bylaw and current county policies will be in effect. These current regulations are quite restrictive in nature and would not allow residents an opportunity to enter into an agreement to address encroachments.
Now our ER Bylaw online presentation question and answer session. So Diane will start off by asking some questions.
So the first question that was received was, how was the bylaw developed and can it be amended?
So since 2018, administration has completed multiple public engagement sessions and held discussions with council regarding the use of environmental reserve lands. The new draft bylaw is a balance of the feedback received through multiple public consultations, provincial regulations, and the county's own environmental and land management goals. The draft bylaw is proposed and has not received first reading. However, when passed, like any other municipal bylaw, it can be amended by council.
Another question received was, do my property lines extend through the environmental reserve when I have an encroachment agreement in place? And if I have an agreement, can I do whatever I want in that location?
So the short answer is no. The environmental reserve parcel is one large parcel. Private property lines, imaginary or otherwise, do not extend through the reserve. In some instances, there is a perceived ownership of the ER from abutting landowners. However, these lands are municipally owned and are intended to allow for public access. An encroachment agreement may be approved, but that agreement does not give exclusive rights to the lands. Furthermore, each agreement that is approved will be for specific use and location. They'll have a schedule included that will contain a map highlighting the portion of lands identified in the agreement, along with standard conditions and a yearly requirement to provide proof of general liability insurance for the agreement to stay valid.
Another question was received was, do boat lifts and piers have to be directly in line with the applicant's property, or can they be anywhere on the environmental reserve parcel?
So abutting landowners will have the ability to apply for a license of occupation agreement for storage of personal docks through the winter months. Within that agreement will be a list of conditions along with those in the bylaw that will provide direction to accommodate the storage. It will be an expectation that the boat lift piers are stored in alignment with the applicant's property. Now, this exception is intended for landowners that abut steep embankments that make it difficult for regular storage within their own property boundaries. If there is no steep embankment, then boat lift piers shall be placed within the abutting landowner's own property boundaries. The placement of docks and boats lifts once in the water are not municipal jurisdiction, and they are placed as per their temporary field authorizations received from public lands.
So this is a good question that comes up quite often. What is the meaning of natural state? Is it mode, a clean beach of debris, of weeds?
So this reference comes from the Alberta Municipal Government Act, MGA, Division 9, Section 6711. Environmental reserves must be left in its natural state or be used as a public park. Natural state means the natural space with biological or landscape features in which is intended to ensure the protection and sustainable use of the environmental reserve. A state caused by nature, not made or caused by humankind. There are many examples of natural areas. These are the locations where natural vegetation and trees remain intact. Mowed and mechanically cleared beaches do not qualify as natural state.
So sort of following that question, the draft bylaw states to be left in natural state or used as a public park. Who determines what the land is used as a public park? A few neighbors who just want the mowed look?
So natural areas and or public access trails will be created at the discretion of the county and done so in a safe and environmentally responsible manner, taking into regard the intent of environmental reserves. The designation of these areas will be determined by the Parks and Recreation Department, and maintenance will be completed by municipal staff.
The next question received, Are you expecting lakefront owners to let their inherited beaches go back to a natural state or allow them to stay as status quo?
So designated environmental reserves in Alberta are owned by the municipality, in this case, Laklevish County. Beach areas within environmental reserves are not and have never been owned by abutting property owners and are not inherited or inheritable. Additionally, the bed and shore, which is located between the environmental reserve and the lake, is under the control and management of the provincial government. The municipally owned areas will need to be allowed to naturally revegetate to a natural state with the exception of the proposed allowable uses provided in the draft.
So the next question, county residents should have the opportunity to cut and clean up standing dangerous trees and downed trees in the ER because county staff will never get to them. Is it too much of an undertaking for staff?
So the county does currently and will continue to identify and remove hazardous trees on municipal lands that pose a safety threat by windfall to structures on neighboring properties. This is the process to ensure that only hazardous trees are removed from the environmental reserve. So please contact the county or send notification through the county via the See Click Fix app to report a hazardous tree.
Another question received is you're not allowing ATVs on ERs, but you will allow county staff on for completing operations of maintenance and or repair. What's next? No ATVs on road allowances, on leases, or municipal reserve?
So reserves are intended for pedestrian traffic. As per the current land use bylaw C-133, no person shall operate, drive, or abandon a vehicle, an off-highway vehicle within or upon any municipal lands, which include municipal and environmental reserves. Off-highway vehicle use is further regulated by the Laklevish County Community Standards Bylaw and the Traffic Safety Act. The proposed bylaw is for the regulation of county-owned environmental reserves lands and does not speak to provincially owned public land use. Environmental reserves are created at time of subdivision. These lands have established infrastructure and in most of the locations, residences. These areas were not intended for open ATV use. Those uses are better suited for designated provincial trails, not residential subdivisions. There will be times that county staff will need to operate a service vehicle on these lands to allow for the regular operation of the municipality, such as hazardous tree removal, invasive species control, or for the remediation of the lands.
So why do I need a permit from the county for a pier and boat lift? Most residents have one from the federal government, Oceans and Fisheries.
So a temporary field authorization, or TFA, is now required from the Government of Alberta to place a seasonal dock or mooring structure on Crown-owned bed and shore for longer than 14 days. If you're not the waterfront landowner, the province requires you to obtain written consent from the waterfront landowner before an authorization may be issued. Upon request, Laklevish County, as the waterfront landowners, can provide municipal consent for the purpose of crossing reserve lands for the placement of seasonal dock mooring structures adjacent to the environmental reserve to serve as an attachment to your TFA application. As far as the draft ER bylaw is concerned, a permit authorization would only be required to store a pier boat lift within the environmental reserve through the winter season. Piers and boat lifts stored wholly within private property boundaries do not require permit authorization from the county.
Question received was, I would like the public beach made public again. Beachfront residents have developed rights to the water. They have boat lifts, docks, fire pits, chairs on the beach, etc. Their dogs come out of and chase you aggressively. You cannot walk down the beach freely or safely. I would like the area made available for day use and posted as such every 25 meters where there are lakefront properties.
So the draft bylaw does address the private use that is a concern throughout the municipality. The intent is to regulate and manage environmental reserve lands in order to promote the safe, enjoyable, and reasonable use of the municipal lands for all county residents. It is a county goal to protect and sustain the valuable natural assets our citizens and visitors enjoy. Should there ever be a safety concern with an unleashed aggressive dog, then please contact the county complaint line immediately for notification.
Activity on the bed and shore is regulated by the Oceans and Fisheries Department, not the province of Alberta and or the county.
So the draft ER bylaw does not give direction to what can occur on bed and shore, which is a provincial responsibility. The proposed ER bylaw only applies to municipally owned environmental reserve lands. Section 4.6 of the draft ER bylaw acknowledges that the bed and shore lands are administered by Alberta Environment and Parks under the Public Lands Act. The province owns and manages beds and shores of permanent and naturally occurring bodies of water. The province of Alberta provides information on their management practices and regulations, and this information can be found on the Government of Alberta website.
So another question received is, I have concern about the destruction of the environmental corridor by off-road vehicle use all summer and winter long, despite the signs posted in the past couple years restricting motorized vehicles. This careless action has uprooted and rutted the public walking trail, making it dangerous for residents who respect the regulations. Can those areas be blocked off to stop vehicle access?
So off-highway vehicle use is prohibited on reserve lands in the current land use bylaw. Additionally, the new draft bylaw provides clear prohibitions and the ability to fine repeat offenders who are not respecting county bylaws. If there are areas of environmental degradation, then please contact the county or send notification to the county via the See Click Fix app so that the area can be inspected and, if necessary, to have bollards placed to prevent further vehicle access.
How or who will determine minor or major encroachments?
So the definitions of minor and major are defined in the bylaw. An area that is covered by 20 meters square or greater is considered a major encroachment, and an area that is covered less than 20 meters square is a minor encroachment. All encroachment applications will be reviewed by the Planning and Development Office. Verification of what will be required will be explained in the policy and procedure that will accompany the bylaw. For example, requests for a major encroachment agreement shall be submitted to the Planning and Development Department. Written request, including the legal description of the lands upon which the encroachment exists, must be accompanied by a copy of title no older than 30 days, a real property report no older than a year showing the encroachment, and an application fee as described in the Lakefront County Encroachment Agreement Policy. Dependent on the type of encroachment, the application for an agreement will either be considered by council or the Planning and Development Manager.
So are citizens expected to approach county administration for physical review of property for potential encroachment issues?
It is an expectation that residents do their due diligence to ensure that any work being completed on their property is done so with the correct permits in place and within their own property boundaries. Residents are encouraged to utilize the county online mapping system, Unisite, to view their property boundaries, as well a request can be made to the Planning and Development Office for a copy of the survey plan of your property to determine if there may be a possible encroachment. If there is an encroachment on county land, then it would be in the best interest of the abutting owner to contact the Planning and Development Office to review the remediation options available to them.
If an encroachment were created over 20 years ago by a previous owners, how will this be handled in regards to remediation of the reserve area? Will there be a possibility for relief for minor encroachments made by previous owners?
So regardless of who placed the encroachment, it will be required to be remediated to the standards set forth in the bylaw. Except where permitted, all encroachments on environmental reserves are prohibited, regardless of whether such encroachment predates the passing of the bylaw, and they shall be brought into compliance in accordance with the new regulations. Should the new budding landowner wish to retain the encroachment, they will have the option to apply for an encroachment agreement. If there is an agreement and no budding owner claims, if there is an encroachment and no budding owner claims ownership of the encroachment, then it will be removed by municipal staff and the area be allowed to naturally revegetate.
So it seems the intent of the bylaw is to get encroachment agreements in place rather than have major encroachments removed. Will major encroachments be automatically approved if there is an application for an encroachment agreement and a fee paid?
So major encroachments will not be automatically approved. Encroachments that do not adversely affect county's lands and interests shall be considered and decided upon by council on a case-by-case basis. There will be consideration taken to safeguard the natural preservation and to indemnify the county's rights and obligations with respect to environmental reserve lands. The county shall endeavor to remediate unauthorized uses and/or encroachments. Remediation direction can be in the form of a voluntary remediation request, removal, issuance of a ticket, an order, or by application of agreement where appropriate. Further, any existing encroachment that receives agreement approval shall stipulate that the nonconformity may not be enlarged, structurally altered, added to, rebuilt, or extended beyond the bounds of the current use, except for routine minor maintenance of the encroachment. In the event of an existing encroachment that receives approval by way of agreement and the use is not normally permitted in the bylaw, is subsequently damaged or destroyed to a certain prescribed extent, the encroachment is not to be repaired or rebuilt except in accordance with the municipal bylaw and policy.
So why are potential environmental concerns not listed as considerations in encroachment agreements? For example, the bylaw only refers to liability, operational, financial, and public safety issues.
So the environmental integrity is a consideration throughout the bylaw. As stated in the bylaw draft, council has deemed it necessary and in the public's interest to pass a bylaw to regulate and control the use of environmental reserve lands within Lac La Biche County in order to ensure public safety, natural preservation of these lands, to prevent pollution of adjacent water bodies, and to provide public access to and beside the bed and shore of adjacent water bodies. Additionally, should an encroachment located on reserve lands that receives authorization at any time cause environmental damage, or if there is an apparent risk of environmental damage, or the encroachment obstructs public access to or within the environmental reserve, as decided upon by the county, the owner will be required to remove the encroachment and to remediate the area.
Another question received was, is an encroachment agreement required for existing stairs that go down to the beach but are not on the beach? If so, will these types of agreements be time limited or contain restrictions?
If any portion of the existing stairs are encroaching ER lands, then yes, an agreement would be required for it to remain, or it will be required to be removed. The terms of the encroachment agreement shall be for a specific time frame or the effective life of the structure, whichever is shorter. All expenses, costs, liabilities, or other risks associated with any encroachment shall be the responsibility of the applicant. Furthermore, the applicant shall provide the county with evidence of general liability insurance coverage regarding the encroachment and the encroachment area in a form and on the terms and conditions satisfactory to the county.
So is land that were subdivided in 1970, so before the Municipal Government Act created environmental reserve, still covered under this bylaw?
Yes, in older subdivisions, any county-owned land which may have designation described on its certificate of title other than environmental reserve under former enactment, for an example, R for reserve or PR for park reserve, which appears to bear the traits of an environmental reserve as defined in the MGA, shall be considered as ER and be subject to the provisions of the bylaw.
So how will the county enforce this bylaw in views of the large number of potential non-compliant developments? What additional resources and training are being made available for for protective enforcement. Oh, sorry, proactive enforcement.
So Lakefront County will identify unauthorized uses and encroachments through observation by staff in the performance of their duties or through a complaint process. During the process of creating the environmental reserve bylaw, staff have already identified existing non-compliance issues, and we have been waiting for the bylaw to pass all three readings in order to start our compliance process. There has also been an educational element to the engagement sessions held to date, and many abutting landowners have come forward as stewards of the land. Additionally, enforcement services has been part of the environmental reserve project from the beginning and understand the implications it will have on their staff. All residents will play an important role in the protection of the environmental reserves in our municipality.
So the draft bylaw states not to disrupt or remove the natural growth of any vegetation. Does mowing considered to cause disrupt and injury? Pathways are allowed and likely mowed. Is riparian land protected from generalized mowing?
So yes, mowing is prohibited and considered a cause of disruption and injury. However, there will be an exception allowed to abutting landowners to mow and maintain a single meandering trail, which shall be a maximum of 10 feet wide. This exception does not include any portion of the bank, bed, or shore. That area is to remain untouched with the natural buffer left intact.
Can you please explain why, if there are prior written submissions regarding the ER bylaw, that we are still seeing the same version of the draft bylaw?
So the 2020 draft bylaw version that is before you today has been crafted with amendments made which considered the feedback received from the public engagement sessions held since the 2018 draft version. The new 2020 draft was circulated to internal county departments and to county legal representatives. On December 8th, 2020, Council approved the new draft version of the Environmental Reserve Bylaw 20036 and directed administration to conduct a public engagement of the draft prior to first reading. We appreciate the time the residents took to review the draft bylaw and to provide their comments and questions. All the comments and feedback received will all be collected and provided to council to review prior to granting first reading. It is at that point where council may choose to make further amendments or proceed with the draft version as is. And that concludes our Q&A session.